STAJ. That is the agenda of Chief Justice Martha Koome. Social transformation through access to justice. Among those things, of course, is ensuring that our constitution aligns with everything else, including our penal code, and making it easier for people to access justice. Today, we want to have a conversation about looking at the reforms that need to happen so that our laws are aligned to the constitution, especially in the criminal side. We are joined by the Honorable Lady Justice Grace Ngenye. She is a judge of the High Court and also the chair of the National Council on the Administration of Justice Committee on Criminal Justice Reforms. Judge, good morning.
Good morning.
Welcome to Kenya's biggest conversation.
Thank you.
Karibu sana. We also welcome again into the studio, he's been here before, the Honorable Wakili Edward Muriu. He is the MP for Gatanga constituency and a member of the National Assembly Justice and Legal Affairs Committee. Wakili, good morning.
Good morning, Latiff, and my good friend, Mr. CT, and my good friend, Ndu.
Bas, got it.
I'm so proud to be back here again.
Very good.
This early morning. First and foremost, allow me just to bring you warm greetings. Despite the cold weather this morning, allow me to bring you warm greetings from the great people of Gatanga constituency.
Very good.
And also, I'm also very proud today because of pulling out a judge from the bench and bringing her to the spice.
Very good.
I think you are all might and powerful over here, the spice. And Justice Ngenye, I'm so proud also that we've been to college together. And maybe for your information, Justice Ngenye and a group of other 6 girls, they used to go together as a group. And they were first year and I was a third year. And you know, in a group of 6 girls, to be able to get attention of only one is very difficult because they're always chatty with one another. But by the grace of God and the grace of the rains and the storms, I was able to snatch one of the girls in the group who was her very good friend, who eventually ended up in my house, and I gave her a title of my wife. Her name is Maria.
This one has a happy ending.
So I'm so proud to be here because again, what happened at the campus is that everybody went their own ways. Justice Ngenye joined the judiciary. I went for the commercial practice. And I'm so proud that
you remained in the bar.
I remained in the bar.
On the bar.
I should remain on the bench.
Within the bar.
Yes, but there was nothing to drink in the bar. And eventually we've met again. Happily that I'm meeting her again in my committee of Justice and Legal Committee. Now this time not as a magistrate, not as a judge, but a judge of a court of appeal. Am I right?
Actually,
so
court of appeal,
you need to be very careful, Latiff, when you say judge of the High Court.
Yes.
That's an understatement. It's judge of the court of appeal.
Sincere apologies.
And,
JA.
I'm also very proud that I am the one who received the proposed amendments to modernize our penal code on behalf of the Justice and Legal Committee of Parliament. And maybe also, I'm also very proud that for the first time in the history of the Republic of Kenya, the consumers of the law, or the people who operationalize the law, have taken upon themselves to bring up proposals to amend the law to suit the situation. That is amazing. It's an unprecedented. It has never happened before. You may find that in the old constitution, it's only Attorney General who had the power to bring new laws. Today, under our new constitution, everybody, either individual institutions, they have the capacity now to change the law, propose the law, bring them before Parliament. And I'm so proud that the old piece of relic, the old law, that's the penal code, has been able to bring an attention. And the beauty about it is that it's an omnibus.
Very good.
There have been small amendments here and there, but I think these are omnibus repealing of the penal code.
We'll get into the details shortly. Thank you very much, Wakili.
Yeah, thank you so much.
To welcome you to the conversation, and yes, judge of the Court of Appeal. I'd seen that earlier, and then saw something else, and it totally confused me. Sincere apologies, Judge.
Yeah, it is all right.
To welcome you to the conversation, CT has the day's proverb. He always has a proverb, and every week he picks one country where he goes and gathers some interesting proverbs. This week's proverbs are?
From the Tanzania. This, for last 2 weeks, well, we were first in Kenya, then we went to Uganda, now in Tanzania.
Mm-hmm.
So we dedicated these 3 weeks to the 3 East African countries.
Mm.
The bitterness of a son is known by the parents.
The bitterness of a son is known by the parents.
That's the
Malady.
Yes.
What do you make of this proverb? What's your interpretation?
Thank you very much, Latiff. But even before I get into that, Mheshimiwa knows me too personally, and so he can speak so much about me. And it is true, our journey began quite far, in the 90s. Latiff, you must be much younger, I know.
Well, in the 90s when you were doing what you were doing, I was doing something else.
Exactly. And we have come this far. Yeah, but before we get into that, receive a kind greetings from my boss, the Honorable the Chief Justice. In fact, I'm here with her blessings. And we engaged them, the JLAC members. And as he says, it is very true that he's the person who received the bills. In fact, I have copies of our bowed proposed amendment bills. What is interesting is that these statutes, the Penal Code and the CPC, are as old as about 70 years. And the last time there was a holistic amendments to them was about 1930. So for us as a committee, NCCJR, in short, under the auspices of the NCAJ, are quite honored that we have undertaken this journey to ensure that the two statutes are holistically amended. And as Mheshimiwa says, of course, there have been piecemeal bills that go to Parliament intending to amend and have amended piecemeal provisions of the two statutes, and therefore ourselves being charged to overhaul the entire criminal justice system in Kenya, and then by extension taking it upon ourselves as one of the terms of references for the committee's output to overhaul these two statutes is no mean task. And let me tell you, we have traversed this country. We have been able to get views from themselves as parliamentarians, from all stakeholders in the criminal justice systems, consequent to which we have been able to compile this piece of work. And therefore, we are happy to engage the Republic of Kenya to tell them exactly why we want to overhaul these two statutes. And we have, let me just now give the basic background. Yeah, we have the 2010 Constitution.
Yes.
Yeah, which is quite progressive in nature. So if we do not progress other statutes to align with the progressive Constitution, then we are doing zero work. Starting with the Penal Code, as colonial as it were, it uses very derogatory words, particularly for persons who are sick with psychosocial, intellectual, and mental disorders, such words as imbecile, idiots, insane person. And, people do not know that persons who have mental disorders, who have intellectual and psychosocial disabilities, are sick people wanting treatment. What about persons who attempt to commit suicide, Latiff? These are also persons who are sick. Really, do you need such a penal offense in our statutes? No. So we need to divert these persons elsewhere, where they can get treatment, where they can get counseling, and other kind of support. We also have other provisions that we need to amend, for instance, to decriminalize and reclassify petty offenses. What happened before the formation of our committee is that a study was carried out by the National Council on Administration of Justice, conjunctively with the Legal Resources Foundation and the Resource-Oriented Development Initiative, RODI, where they found that the justice system is biased against the poor.
Yep.
And I think that is not an understatement. It's a fact, Latiff. So much so that those persons who are poor, they are charged. They find their way into jails. As a result, our jails are congested up to 70% by petty offenders.
Yep.
So what can we do as a committee and to help this nation so that we reverse the situation? So we have proposed to delete the petty offenses that are provided for under the Penal Code.
Delete.
Delete them.
What does that mean?
Delete them is to
Decriminalizing.
remove them so that petty offenders, the very minor petty offenders, you know, I think we need another session for us to define what petty offense is.
Yeah.
But we have very minor petty offenses like falling the air, insulting, going on the streets for purposes of prostitution, minor trading on the streets. You know, we want to remove them from the main penal statutes. But that is not to say there is no justifiable cause to punish such persons. Otherwise, we would have a lawless society. As a result, we have proposed ways of punishing them, diverting them. You know, you can give a warning, you can give them community service, you can put them under probation, you can ask them to sign a commitment to keep peace, etc., etc.
So we are not decriminalizing.
We are decriminalizing. To decriminalize, Latiff, just means that you remove such petty offenses from the main penal statute so that they do not have to go before a magistrate, take those pleas, and they are taken to jail. And even if that were to happen, they do not have to be placed under custodial sentence.
Okay.
Simple as that. So it is a big debate, and I think we go on. I can stop at that so that I can see Ms. Du wants to say something.
I want to ask a question. Maybe we can
Yes.
take a few steps back because
Yes.
the penal code at its earliest, what is it meant to do? Because now we are saying, let's make some changes to it, but a code, obviously, something that you then go by, right? So what was it originally established to do?
It's a very simple answer. Penal code. What is penal? It's an offense. What is penal? It is to punish. So penal code provides for offenses that are punishable by law, and that is why we have the code. The code is what spells out what offenses are punishable and by what sentence. As simple as that. Then we have the Criminal Procedure Code. The Criminal Procedure Code, as the word procedure provides, is a process. What is the process of effectuating the penal code? As simple as that. So we have the offense statute and the manner in which we punish those offenses. And then we have the procedural statute, the procedures through which we effect the penal code. It's as simple as that. I hope that is simple.
And those two go
explanation.
hand in hand.
Those two go hand in hand, but they must not necessarily work conjunctively, because if you are charged, for instance, or an offense of stealing under Section 275 of the Penal Code, it does not mean that I must necessarily have to refer to the CPC, that is the Criminal Procedure Code, to know how to punish you. Yeah.
You know, if what you just said only required a little knowledge of the English language and understanding what is being said, then I would agree with you.
Yes.
They are simple. But when you then involve the human person in their various capacities and you want to actualize it, then there's nothing simple about it.
True.
Because then the individual comes with their wherewithal and with their own understanding and with their own biases.
Yeah.
Yes, it provides a guide, it provides a platform, it provides a structure within which one can work. But the thing that I find perhaps most disturbing is even when it's as clear as you're stating it, internalizing it so that it is actually used to achieve the purposes for which it was intended. And in the case that you have here, that's amidst the baggage of this penal code that you're trying to repeal. Because that is what has formed the mindset of those who are in the justice system.
It is very true. Thank you very much. It is very simple, and that is why we want to reform this criminal justice system, because we have the code that is the Penal Code itself. It is providing for offences and it's providing for means of punishment for those offences. But clearly, when we come now to the justice sector, that is the adjudication process, where we find that people are not quite applying it the way it is supposed to be applied. So much so that if you are charged with a smaller offence, that is a minor offence, you, instead of applying an objective mind, so that you do not necessarily have to go to jail, those persons are being sentenced to custodial sentences, whereas you have an option of even warning this person. You have an option of placing this person under a probation. You have this option of even asking the person, please just commit yourself to keep peace and not to commit an offense.
Yeah.
That is it. But incidentally, you find that the justice sector has this mentality that since you have made an offense, the right way and the proper way and to satisfy the society is just to put you in jail.
Yeah.
And consequent to which I will just apply the custodial sentence. That is why now we find our own jails are full of these petty offenders. So really, the sensitization is very important. One. Number two is that for a person to just get to court or where you are working from to see the Penal Code and to see an offence, provided for becomes the eye catcher that this is what I'm supposed to apply. And therefore, Mr. Latiff, if we remove it from a statute that is always on your table on a daily basis, then you have no basis to do what you ought not to do. And you have the basis to do what is right. As simple as that.
We've actually had very many conversations on the show about petty offenders and the petty offenses and looking at the injustice that's meted out on people. Just because you are caught, I don't know, throwing garbage somewhere and you're taken to court and a judicial officer sentences you, first of all puts you in remand, let it 20,000 shillings bond or bail. And you can see it's impossible for this person to raise that kind of bond or bail. And we've been raising this issue. So this is something that has been there for a long time. So of course, reforms in this sector are absolutely what we need. However, and I want to come to you, Wakili, as legislator and also as a lawyer. It's taken us so long to actually get to this point where we are reforming and reviewing the Penal Code and the Criminal Procedure Codes. That means that we need to have some change of behavior and change of our own understanding as jurists, because all the jurists before you have just been applying this, and they always argue, the Criminal Procedure Code restricts me from thinking beyond this and applying my humanity and looking at this. And then we, the citizens, don't really understand the Penal Code, this, and the other. We just hear police telling us, Penal Code, 252 Penal Code. We hear lawyers saying,
according to the Penal
we don't
Code.
understand. Now it's come before you, and you have to come and consult us as you now look at whether this should actually pass into law. How are you going to sensitize the public so that we can all feel that, yes, everything that the NCAJ has actually, and the committee that's led by Justice Ngenye has been working on, is comprehensive and will bring justice to us, the citizens?
Thank you. Trying to put this issue on what you call digestible pieces. Because sometimes we might be too legalist and we lose our audience. This is a process of, number one, breathing life to our new constitution. And maybe just to answer your question on the timing, is breathing life under the new constitution to comply, in particular, on the Bill of Rights. And number two is to relook again, because if this bill, the Penal Code came up in 1930, so you talk about close about 78 years, and therefore it was not meant for the common Kenyans who are walking on our streets. It was meant. It's a law which was built up by a colonial master against.
It was to control
the colonial against his subjects. And that's why you find, even in terms of definition of certain terms, imbecile, idiots, you find it in our current penal code. So, and that's why I'm very proud that this proposal will first and foremost resonate very well with the common man, because as Judge of Appeal has said, the petty offences predominantly affect the underprivileged, not because they are criminals, but by the state of the economic status. That's why they find themselves in the wrong place at the wrong time, and therefore, yes, I want to agree with her that it is timely, and it's addressing the common man, from the language to also from the language, the language of the penal code, and the penal code is a law like any other. But to use the word code, code is an arrangement of things. Is civil procedure code, penal code. Penal code is just you can even call it criminal law. Okay. Criminal act, just to make it much easier. Number two, you will find that because this law was predominantly made by the colonialists to rule against the subjects, it does not serve the 21st century in terms of the current way of doing things. Do you know, my good people, that hawking was a criminal offence under the old penal code? Is actually currently hawking, and hawking is basically a petty trader selling jugu karanga, selling sweets on the streets, selling handkerchief. That's a criminal offence.
And dawa ya mende.
Do you also know that falling the air is a criminal offence? Yes. You know, cities look at me surprised. Yes, falling the air, because during the colonial times, if you go to in a museum, I think the Muzungu was expecting is only the blacks who can fall the air, and it became a criminal offence. And those are the things we are talking about. Let me also point out, do you know that there is no criminality in prostitution? The crime is earning from prostitution, and that's why there's another funny law called loitering without a purpose. Because if then there is no a crime called prostitution, and the crime which arises from it is if you benefit from the income of prostitution, then they may have to look for a way of ensuring they catch you, because how do you prove that I make a living through money obtained from prostitution? It's shambolic. And therefore that's why they brought in that petty law called loitering without a purpose. And I'll tell you this. If you go to our course today, and I'm very, very happy that we are at this juncture. Today, if you go to our courts in Kibera, Makadara, in our normal law courts on a Monday, you spend about almost 7-8 hours, and the crimes you hear is a crime of vagabond, crime of loitering without a purpose, drunk and disorderly, all manner of things. And I think where I'm as a legislator, where I think that where the rubber meets the road is that we are addressing repressive laws which affect the common man each and every day. And that's why I'm very hopeful and very optimistic that this law will see the light of the day in the floor of the House, because we'll be talking to the people, because that's the kind of complaints we get each and every day. And you said it, where we also need to look into is on the area of punishment. Does it mean that every petty offense that one has to go to jail?
Everything I'm hearing is that this penal code has to be overhauled completely. And we're looking at the harm that it causes, whereas it was intended to actually bring about order and something good. But then there's something else about anything that, from what I hear, is harmful. those who operationalize it, those who are given the mandate to put it in place, they do not escape unscathed. If a law, a penal code traumatizes people, those who apply it are equally traumatized, if not brutalized. Because if you're constantly applying something repressive, you are involved in that process, it also changes you and you become something that ordinarily you are not. And now that segues into what her leadership was talking about with regards to mental health. When you find the people who have been involved in applying this penal code, you only need to look at how Kanjo officers treat hawkers. You just need to witness it once. And you marvel. If you look at the way some of our security officers go about the business and how they treat the lowly and the least and the most vulnerable, you have to ask, how are we going to handle the mental effect that this penal code has had on those who are trained to apply it? The leadership, over to you.
Thank you very much. Let me say this. Change come because of circumstances.
Yes.
Isn't it? Because going back to our history, Latiff and City, we did not know how to dress formally and in the suit that you see me dressed in, isn't it?
We had a form of, we had our own suits. We had our own suits, yeah.
Exactly, we had our own suit, but not the suit we are wearing, isn't it?
Yes.
So what I'm saying is this, these books you see us reading, called The Cause and many other things, came with somebody. We did not have them. So they were imposed on us and placed on our tables, and we started reading them. And for your information, Kenya is a jurisdiction that applies the common law. So the laws that you see us applying come from Britain. That is what we call the common jurisdiction, common law jurisdiction. So what am I saying is that we were brought these laws, and as we became modern, and I'm not saying that we were primitive, but as we became evolved into the white man's ways, we adopted their laws. As simple as that. So we read their law and we continue to read their laws. So then circumstances keep changing, and we see that these laws, or whatever it is that we started applying, is not suiting our circumstances, and therefore we have to change it. So, City, that is the answer to your question. So, currently, the Penal Code is not being overhauled as one section to the first section to the last section. It is only that does not suit us. That is where I was coming from. So, whatever we see is not in accord with our constitution, we are going to change it. Just as Honorable Muriu said, for instance, under Chapter 4, the Bill of Rights, we have a provision under Article 49 2H of that constitution that currently bail is available to every accused person.
Yes.
But when you go to the Penal Code, we find that some offences are not bailable. Don't you think we need to change that to accord it with what the Constitution provides?
Yes.
That is what exactly what we are talking about. Number two, now coming down to your issue on mental health, we have now come to know that persons who are mentally unwell are not what we call mad people. Insane presupposes that this basic thing, mad, you've gone haywire, to just speak in simple words. So we know that these are people who are sick. And now with the view to aligning the Penal Code and the Criminal Procedure Code to accord with the medical care that these people require, we are going to amend, one, the use of the derogatory words, number one. Number two, the manner in which we deal with the mentally unwell persons. Okay. So what are we saying? We are going to involve from the date that you take the plea, and the court is of the view that this is a mentally ill person. You rope in an expert, and these are psychiatrists who are going to assess this person and are going to give a review of their mental status. So much so that if a medical expert is of the view that this is a person who cannot take plea, and this is a person who committed an offense when they were mentally unwell, honestly, is it a person you can try? No. So the right thing to do is to discharge such a person. That is just 1 minute to discharge such a person.
Okay.
So if, for instance, they may have gone through the trial process and the court comes to a final decision that when they committed the offense, and of course with the help of the medical expert, that they were not in a position to know that what they were doing was wrong. The current state of the law is that the court is supposed to enter what we call a plea of guilty, but insane.
Okay.
And you are required to be detained at the president's pleasure. So what does this mean? We have roped in the executive. The president is an executive person, is not a judicial officer nor a judge. So we have roped in the executive to play the role of the judiciary or a judicial officer or a judge. So we want to remove that portion so that you cannot be detained at the president's pleasure. Neither can the court enter a plea of guilty but insane, because at the time you committed the offense, you are not in a position to know that what you are doing is wrong. The only right thing that can be done is that you should be acquitted.
And further to that?
And after your acquittal, then the question that now has become very problematic, where do you take this person?
Yes.
Because you have acquitted them.
Yeah.
Of course, we have the family, and we ought to have called for what we call social inquiry reports so that they are brought to the court, and the court would know where to take this person immediately they are acquitted. The most unfortunate thing is this. For those people who have been mentally unwell for so long a period, the family members don't want them.
Exactly.
And yesterday I was in a session where I was inducting newly appointed magistrates, and that question arose. Secondly, I have been called by so many judicial officers because they think also that I have all the solution to some of these questions, and they are having such persons who cannot understand proceedings, and their family members are also not willing to take them in. So how do we deal with them? As the chair of this committee, I may not have a full answer. The thing is this: I've provided a framework, and of course through the consultation, on how we can deal with them, but they are a reject in quote.
Yes.
So what now we are proposing to do is to write a cabinet memo, which through the chair of the NCAJ, that is the Honorable the Chief Justice, can hand it over to the executive, and a middle home can be established by the government, where these persons now can be confined because nobody wants them, and they can get all the facilities that they want, be it medical, be it sanitation, be it housing, in a manner that is humane and can cater to them. I think, Latiff, there's nothing better than that we can do. And why do we say that?
The state should be mandated to take care of these vulnerable people.
They are mandated currently, but in circumstances that are not humane. Why do I say that? Currently, persons who are either convicted but found guilty but insane are rotting at the Madari Maximum Security Unit, Madari, currently National Madari Teaching and Referral Hospital. And nobody goes to look for them. Nobody goes to look after them. If you visit that unit, Latiff, you will shed tears. It is in such a deplorable condition. The roofs are leaking, the beds are not in good situation, and they survive by the day,
And Judge,
by the mercy.
The risk here is that the state will transfer them from that facility into this new one that you're asking the cabinet to create, and it will be the same.
I don't think so, Latiff. It will not be the same, because the Ministry of Health, even currently, because there was a task force that was established by the Honorable the Attorney General that came up with a proposal that there be a framework and policy guidelines created by the Ministry of Health on policy on dealing with persons who are mentally unwell. So much so that if this institution is established, it will have guidelines on how to cater for them in a humane manner, rather than take them to a purported mental medical institution, but nobody looks after them. If we have regulations, if we have a policy, these are persons who will live not only in a decent institution, but also in a humane circumstances and conditions.
I'm actually glad you are chairing this commission.
Thank you.
The passion you have,
I have it.
You have it by the bucket load, and it's necessary because, forgive us, we are a bit cynical about such things, and for good reason. Because time and time again, we see good proposals, something is put up, and that is like the end of it.
That is very true.
The very thing that is supposed to make it work, the end result is supposed to produce, is not seen. But when someone has the energy and the enthusiasm, at least we can go beyond this barrier that we keep seeing, because there is need to go beyond the barrier. You see, if the government understood, and it ought to, and it's been stated and studies have been done, task forces have been set, Mathare would not be in the state it's in. Just for starters, it would not be.
Without a doubt. But I think, again, just to push that conversation, and you know what you're doing right now, we are doing a public participation. Even in this, what you're doing here in the SPICE, is a public participation, because we are sensitizing our people on the new changes which are forthcoming. And why I'll vote for this bill when it comes for the House is, again, because it has decriminalized certain aspects and thrown them to what you call the civil realm, from the criminal realm to civil realm. And I give maybe a simple example: libel, that is defamation in the civil side, has been a criminal offense. You can go to jail for defaming someone, because libel is a criminal meaning for the defamation. And I think, again, it was meant to cater for certain aspects those days, but I think it has been overcome by time. And the proposal before us right now is that we need to confine libel, the defamation. In law, we call it tortious liability, whereby you need to prove beyond reasonable doubt that the damage has been occasioned to your name and a personality. The failure to pay debts, it is in the Penal Code. It's a crime. It's a criminal. You can go to jail for failing to pay debt, and yet it is not a crime against a person. It's an economic situation. Again, it's repelling to move it away from being a crime into a civil. It's a civil matter, and then just to bring the rubber to the tar, is that you have situations whereby the police, on not on very few occasions, but many occasions, whereby they arrest you because you are given money by certain person, and you're not able to pay. And that's what they use. They use the Penal Code. Say, look, under this section of the Penal Code, failing to pay debt is a criminal. It is offensive. There's no way, police have no role in doing debt collection.
Is that the one they call obtain?
By forcibly text.
Obtain.
Yes, that is it. That's it. That's a debt. That's a debt situation which you're giving a policeman to coerce you and put you in the cells and tell you, look, we shall talk when you pay this debt. Something else very interesting. Urinating in public areas is a criminal offense. On your way home, when you find this too much and you stand by the road, purely because the government or the county has not provided for a place to relieve yourself, it's also a crime. And that's, again, it has to be repealed. What I'm trying to say long and short is this. I'm not laboring at all on the proposals which has been brought by the NCAJ, because they're addressing the common man and little annoyances which happen in each and every day. Number two, the repealing is bringing what you call the humanness in the criminal justice. It's not all about you are being caught on this, therefore you're supposed to pay a fine or go to jail. It's just understanding the human psychology. And I'm very happy that the mental illness here study has been done critically to address the issues which are criminalized in the penal code, in the sense that it's not an omnibus. By you being told you are insane, you find that the penal code is interrogating. When you say you're insane, what are you talking about? Is it a state of health, or is it a state of crime? And therefore,
I want to ask a question as we conclude. 60 years after independence, with an independent government, because we're saying this penal code and the criminal procedure code were brought in to us by the colonial masters, and they had an agenda. But our governments have not been repealing these things. Even now, even as NCAJ is working towards it, it's 10 years after promulgation of the Constitution. That's when we are seeing these laws coming in. How do we trust that the players in state who like the control that this criminal procedure code and the penal code has given them will let go? How do we trust that even what is contained in this bill will not get some amendments that will still favor those that want to hold on to the levers of power and control over the weak and meek?
I think, just to answer your question, the growth of jurisprudence, and that is the growth of the law, the regulations, the law and order in any organized society, is an ongoing process. It's a work in progress. Even democracies which are 1,000 years today, they still have a parliament which keep repealing, amending laws to suit situation, because nothing is static. Everything continues to evolve. And a good example is what we have right now. We have, as you said, we have a constitution which is about 10 years now. 13 years and counting. Remember, the constitution is supposed to serve generations. And in fact, and I said, in my opening remarks, I said, this repealing amendment and the change of the penal code is breathing life into the Constitution. And a good example, I think the Justice have mentioned about the children's right. Article 53 is very powerful on the rights of the children. If a child happens to be in the mix when she's in the stomach of the mother, when the mother has been committed to jail, the question is, when she's born, is he supposed to live in prison because the mother was imprisoned? And that's why you find that has already changed. Secondly, again, you just also to say this. Article 53, and just to see where we are coming from, CT. Children's right. Like, for example, yesterday, I on a motion which I sponsored in Parliament, simple thing like feeding program for our schools has never been implemented. Article 53, 1C, 1B and C states clearly, number one, every child is entitled to compulsory, to quality basic education. And C, it says every child is entitled to quality nutrition. So quality education and quality nutrition goes hand in hand. And that's why you find a man like Moi, you had seen very far. Me and Grace most likely we were enjoying the maziwa ya Nyayo. And let me just finish it. Yesterday on a motion which I exposed in the Parliament, we passed a motion that the government must factor in not only providing the quality education, but also quality nutrition. So when you're capitating money to support that child in primary school,
you should feed them as well.
In junior secondary school, you must also provide the food.
Wakili, thank you very much for joining us. Imagine the time runs out this fast when you have a lot to say.
Just as well to say 30 seconds or
30
something on the death sentence.
Yes.
30 seconds, yes.
Thank you very much, Asiti and Mheshimiwa. I think just give me another 30 minutes to say something.
Minutes?
Seconds.
Seconds, 30 seconds. 30 seconds to say something. Just with respect to the petty offences. And he said some of them are already codified in the law of tort, that is civil law. For instance, the offence of bigamy, we don't need it there because if your wife feels that you have married another wife somewhere there at Kamukunji, I think let her just file a divorce. Really, shouldn't be taken to the police officer and charged. Number two, before I get to the death sentence, is that Mheshimiwa is mean. I think they have already taken up this bill. He should have made material disclosure, and that these bills are going to be fronted in Parliament by JLAC after a consultative forum. We have done a lot of consultation and public sensitization. Okay. So we are happy. So when he talks about these amendments, they own it and they feel us. Then coming to the death sentence, I said one thing. We are responding to not only the change of circumstances in our society, but also to the growing jurisprudence. That is cases decided by the court, to which we respond against the death sentence. You know the big case of Muriu. And the Supreme Court pronounced itself and said that death sentence under Section 204 of the Penal Code is not a mandatory sentence. It could be the maximum. So we have to align our Penal Code to the current jurisprudence. And of course, we know we have proponents of total abolition of the death sentence. And of course, there is a bill, we know that. But we are hoping that if we can merge this and further do public sensitization, then people can say whether do they really want the total abolition of the death sentence or do they want it to be capped as a maximum sentence, and also define what life sentence is. We have done that so that people are not placed in the prisons for an indeterminate sentence. I mean time. That is to say, until you die. Is that humane?
That's the death penalty.
Exactly. It's as good as death penalty. So really, Latiff, I wish we could take this conversation further, and I hope we can come again and continue.
We will.
Thank you very much.
Also, as it continues into the second reading in the National Assembly, we'll have these conversations.
Asante.
Judge, thank you very much for joining us. The Honorable Lady Justice Grace Ngenye is a judge of the Court of Appeal and chair of the Committee on Criminal Justice Reforms of the National Council on Administration of Justice. The Honorable Wakili Edward Muriu is the MP for Gatanga constituency and a member of the National Assembly's Justice and Legal Affairs Committee.
This is the Situation Room, the only way to start your day.